Dear Madam Secretary General Pejcinovic-Buric, dear Federal President von der Bellen, dear Dean Circling Youth, dear members and friends of the European Law Institute. This is now already the second time that the ELI annual conference takes place online for reasons related to the COVID pandemic. This is the second time that we are unable to greet you in person with a glass of good wine or maybe even champagne this year to mark the celebration of our 10th anniversary. Last year, we had planned to hold the conference on the splendid premises of Eötvös Loránd University in Budapest. And this year would again have been the year where the conference would have taken place in Vienna, in the wonderful building of Vienna University, which has been generously hosting the ELI Secretariat for a decade. We had planned for schnitzel and Tafelspitz, for apple strudel and pastries, and for Viennese wine and music. None of this is going to happen, sadly, and our culinary and musical hopes rest on Madrid in 2022. But the ELI has not given in to none of the 4 waves of the pandemic. The ELI is as active as ever and probably more active than ever. I already reported in the membership meeting this morning that we have learned our lessons from the pandemic and found new ways for our internal bodies to work and communicate with each other. And more importantly, new ways of engaging with our members and with the European, or in fact, a worldwide audience. A number of new online event formats have been introduced, notably an Eli Webinar series. This started as a webinar series on the Eli principles for the COVID-19 crisis, but it was soon extended by further series, both on topical legal issues, such as the proposal for a draft AI regulation or the need to adapt the Product Liability Directive to the digital reality, and a series on past Eli projects and on the impact they've had. And I am happy to announce already now that the ELI will start a new webinar format in the autumn as a contribution to the Conference on the Future of Europe. And this new format will explore new avenues of engagement with a still wider audience and the European public. But by no means do we have an intention to turn this organization into a virtual organization. And we are strongly determined to resume our tradition of physical meetings as soon as the pandemic permits. However, we are most likely going to make much more use of hybrid and digital formats also in the future. It is in line with this general desire to return to physical contacts as soon as possible, but at the same time to make ample use of digital options where we find them appropriate and helpful, that we have started the implementation of the new membership software system, My ELI, developed for us by software company Nioxus. And this morning at the ELI membership meeting, we had a couple of presentations on some of the key functionalities of the system. Certainly, it will take some time before the system can go live, and we will most probably start with a limited range of functionalities and a limited number of participants first, in order to remove as many of the bugs as possible, which we are certainly going to see, as is the case with every complex software system. But at the end of the day, we truly hope that this will revolutionize the way in which we engage with other ELI members and in which you engage with us with this organization. From applying to become an ELI member to editing your contact details, paying your dues, registering for events, to joining members' consultative committees or special interest groups, My ELI will offer you a one-stop shop solution once it is fully operational. And as we are all drowning in emails and other lines of communication, I am myself already looking forward as an Eli member to the time when I will have immediate access to all the documents that are relevant for me as an Eli member with a few clicks and always complete and in the most recent version whenever I need them. Concerning international relations, the pandemic and digital formats have facilitated some meetings that would otherwise have caused much greater effort to organize. However, it is clear that flourishing international relations, in particular when establishing contact with new partners across the globe, require a degree of physical presence in order to get a better feeling of the other organization's culture and mode of operations. So over the past months in particular, the Eli has established a number of new institutional contacts, and I'm sure those contacts will prove to be very valuable and to bear fruit, in particular after the pandemic has come to an end and we can start traveling again. That brings me to Eli's main activity, which is projects. Until Wednesday, a selection of 12 current or future Eli projects will be on the agenda of our annual conference, covering a very broad range of different topics. As you may be aware, the Eli Council has identified 3 focus areas on which Eli projects should currently concentrate. These are rule of law in the 21st century, sustainable life and society, and law and governance for the digital age. Our digital pillar, if I may say so, is represented by the project on data economy, the one on digital assets, the one on blockchain and smart contracts, and the one on AI and public administration. The second pillar on rule of law is represented by our project on e-evidence in criminal proceedings, on the concept of courts in family and succession matters, the Eli Mount Scopus European Standards of Judicial Independence, and our project on fundamental constitutional principles. And finally, the sustainability pillar is represented by our projects on climate justice, on corporate sustainability and financial accounting, on ecocide, and on corporate responsibility. These are by far not the only projects which the Eli is conducting, and projects within the meaning of our project guidelines are not the only output Eli produces. We have also introduced a new publication series, which we call Eli Innovation Papers, with which we can react in a more quick and timely manner to current developments where the Eli may need to raise its voice. And we submit regular responses to public consultations, such as those launched by the European Commission. And where we believe it is necessary and helpful, we also produce output, such as the Eli Principles for the COVID-19 crisis, including its 2021 supplement on vaccination, which have sparked very positive reactions throughout Europe and which have already been widely published and translated into several languages. But this annual conference is devoted exclusively to Eli projects, which means Eli work conducted under the procedure foreseen by the Eli project guidelines. To some extent, but not always, the 12 projects that will be presented this year will be presented in the order of the stage they are at, which means that the projects presented first are the ones that are likely to be the first to be submitted to our council and membership for approval. Now, for those of you who are attending for the first time or who are watching recordings of these sessions at a later point, I would like to briefly explain that Eli projects are not just conducted by the small team of reporters and sometimes other project team members whose names you see on the brochure and on our website. Rather, it is the hallmark of Eli project work that projects are conducted under the auspices and close scrutiny of the whole Eli membership. It is our members' elected delegates in the council who are in charge of identifying relevant project ideas and appointing project teams and advisory committees, often upon inspiration received from other Eli members or Eli hubs or special interest group, SIGs. And every Eli member that has the right to join what is called a Members Consultative Committee, short MCC. And the members of those committees have the same rights to receive interim drafts and to debate and influence project results as our appointed advisors and Eli bodies. And no project results may be published on behalf of the organization unless they have received approval, which for most projects, and in any case those conducted under the regular procedure, means approval both by the council, the elected delegates of the membership, and by the Eli membership itself. One of the projects, the Eli Principles for a Data Economy, which is also the first project on today's agenda, has already been submitted for approval. And members are kindly asked to cast their vote until 24th of September. But please do not just concentrate on this project. Please pay particular attention also to a number of projects that follow today and tomorrow, as we expect to present those projects to you for approval before the next annual conference. So please pay particular attention to those projects that appear first on the agenda, because it's very likely you have to vote on them very, very soon. Of course, apart from discussing our projects and making sure all members have a say in how they develop, as every year, we will also use the annual conference as an occasion to announce the winner of the Eli Young Lawyers Award and the winners of the Eli SIG and Hub Awards. Another highlight, which I would kindly ask you not to miss tomorrow night. And of course, the greatest highlight is the keynote speech to be delivered by the Secretary General of the Council of Europe, and we are all very much looking forward to that. Last, but certainly not least, I want to take the opportunity to thank our sponsors that have generously supported this online conference. The City of Vienna, Interlegis law firm that has for a number of years been sponsoring the Eli Young Lawyers Award. Publishers Brill, 11, Hart, and Intersensia. And of course, above all, the European Union and the University of Vienna. The European Union has been supporting many Eli activities with an operating grant for a number of years. And the University of Vienna has generously hosted the Eli Secretariat under consecutive framework cooperation agreements since the Eli's founding in 2011. The Eli is extremely grateful for this cooperation. And it is therefore a particular pleasure for me to give the floor now to Brigitte Zöchling-Jud, Dean of the Faculty of Law of the University of Vienna, who I have to add is also an Eli member. Britta, the floor is yours.
Dear Christiane, thank you very much for your kind introduction. Yeah, dear Madam Secretary General, dear President van der Bellen, dear colleagues, and especially dear friends of Eli. On behalf of the law faculty of the University of Vienna, I'm pleased to welcome you to this year's annual conference. Eli celebrates its 10th birthday this year and has grown to become one of the most important voices of European legal scholarship and practice. Its independent proposals, opinions, and analyses for and of European legal acts are highly regarded and respected, and networking among European lawyers has been an incomparable success. Of course, this is also due to the forward-looking topics Eli chooses for its projects and conferences. This year's conference is dedicated to various topics of digitalization, but also to climate justice, and thus addresses topics on the pulse of time. As Dean of the Vienna Law Faculty, I'm grateful for Eli's loyalty to our university, and I hope this will continue under the future president, Professor Pascal Pigeonnin, whom I congratulate to its election, and I wish all the best for his task. I wish you all a very exciting discussions, and I hope to welcome you in person again very, very soon. Thank you.
Well, thank you so much, Britta, for these kind words. And thank you so much again for all the support we received from the Faculty of Law. Thank you so much. And now I would normally have passed the floor to Federal President Alexander van der Bellen, who already addressed this audience at previous conferences, and to whom we are also grateful for his support of our organization. He may or may not be listening now, but unfortunately, due to a conflicting commitment, he sent us a video message, and we will display this video message now, and I hope you enjoy it.
Dear members and friends of the European Law Institute, as the Federal President of the Republic of Austria, it is my great pleasure to welcome you to the ELI Annual Conference 2021. Since the last time I was addressing you in 2017, the European Union has been faced with many new challenges pertaining to its unity, climate crisis, digitalization, and most recently, the COVID-19 pandemic. ELI's work on the rule of law in the 21st century, law and governance for the digital age, as well as sustainable life and society, represents an important contribution to tackling these European and global challenges. The European Law Institute has been working on improving the quality of European law through research, recommendations, practical guidance, now for a decade. This work is of utmost importance. I would like to take this opportunity to thank the Rector Heinz Engel and the President Christiane Wendehorst for their continuous support and efforts to ensure that Austria is in the center of most important legal discussions. We are proud to be the home of the ELI Secretariat. I wish you all a successful conference with stimulating discussions on legal developments and challenges that are lying ahead of us. I am sure that the discussions in the following 3 days will enhance our understanding of fundamental issues like climate justice or data economy. And on the occasion of ELI's decennial, I wish you many more decades of steady growth and success in promoting cooperation.
Well, thank you so much. Whether or not the Federal President is now listening, we were very grateful to receive the video message. And it's now a particular honor for us that despite the adverse circumstances of an online event, Secretary General Maria Pejcinovic-Buric agreed to be present tonight and to address this audience with a keynote speech. Now, Maria Pejcinovic-Buric is the Secretary General of the Council of Europe, the preeminent pan-European international organization in the field of human rights, democracy, and the rule of law. Prior to being elected in her current position, she was Deputy Prime Minister and Minister for Foreign and European Affairs of the Republic of Croatia, having served previously on 2 occasions as State Secretary for EU Affairs. She has also served as a deputy in the Croatian Parliament. In her speech, The Secretary General will focus on current challenges to human rights, democracy, and the rule of law in Europe, addressing in particular issues of human rights in the digital age, human rights and the environment, as well as violence against women. Madam Secretary General, it's a great honor for us that you are here today, and we are very much looking forward to your keynote.
President of the European Law Institute, Dean of the University of Vienna Law Faculty, Eli members, ladies and gentlemen. It is a great pleasure to speak today to outline some of the contemporary challenges that the Council of Europe is facing and our responses, all of which have implications for European law. Our organization was established in 1949 and exists to protect and promote human rights, democracy, and the rule of law. From 10 founding countries then, it has grown to comprise 47 member states now, each of which has ratified the European Convention on Human Rights. The fundamental rights laid out in that treaty include life, liberty and security, and privacy and a fair trial, freedom of expression, association, conscience, and religion, and freedom from torture, servitude, and discrimination. These rights and all other contained within the European Convention are interpreted by the European Court of Human Rights, to which every one of the 840 million people living in our pan-European legal space has the ultimate right of appeal. Together, the European Convention and the European Social Charter, our treaty guaranteeing social and economic rights, form the basis of human rights protection on our continent. Over the years, the Council of Europe has developed 223 legally binding treaties that apply these rights to specific issues. And these cover everything from the rights of national minorities to combating corruption, cybercrime, and human trafficking, to preventing the sexual exploitation of children. No other continent has ever achieved this. So we should be proud of it, and we should be ready to defend it too, because the harsh reality is that parts of Europe have experienced the rise of populism and extreme nationalism over recent years. And this poses a direct challenge to the values and standards that underpin the Council of Europe. Indeed, it is a threat to multilateralism itself. In my recent annual report, A Democratic Renewal for Europe, I highlight clear evidence of democratic backsliding among our member states. And I make the point that while these trends often predate the onset of COVID-19, the pandemic has created a situation in which they have got worse. Take freedom of expression. Over recent years, we have seen a rise in smear campaigns, wrongful imprisonment, and acts of violence directed against journalists. And following the emergence of the coronavirus, attacks, censorship, and reprisals for questioning government policies have accelerated further still. There are also problems regarding freedom of assembly and association. For some time, restrictive legislation and the misuse of other laws have been shrinking civil society space and limiting civic activism and legitimate protest. Measures introduced during the public health crisis have eroded these freedoms further too. Similarly, the scourge of discrimination against minorities and vulnerable groups has flared. For this, we need look no further than the example of those migrants, Roma, and travelers who were scapegoated and sometimes physically attacked. From what was already a precarious position, those who have least have sometimes suffered the most. There are 2 points to make here. The first is that the European Convention on Human Rights is non-negotiable. Every member state is obliged by law both to implement the treaty and to execute the judgments of the European Court of Human Rights fully and swiftly. And there remain too many cases where execution takes too long to achieve. Yes, there is shared responsibility for ensuring that this happens. And yes, the Council of Europe is here to help national authorities to do this. But under the principle of subsidiarity, the primary responsibility rests at national level. As I said in my annual report, with COVID-related restrictions lifting, this is the moment for governments to recommit to fundamental democratic principles, embracing the Council of Europe's acquis with the European Convention as its cornerstone. More than that, they should embrace democratic culture, recognize diversity as a strength, and turn proactively to multilateralism as the best means to address cross-border problems. Because the second point to make about the public health crisis is that it has in fact proven the value of international cooperation. Certainly, there are lessons for international organizations to learn, not least on the distribution of vaccines. But this was an unprecedented crisis. And the reality is that the primary complaint about the multilateral response is not that it has been too much, but rather that it has been too little. At the Council of Europe, we have responded fully and in line with our mandate. In April of last year, I published a toolkit document for national authorities, confirming that the measures taken in light of the crisis must respect the principle of necessity and be proportionate and limited in duration. Our Venice Commission reinforced that any state of emergency must be subject to democratic control and spelled out principles, conditions, and guarantees that should be maintained, including in the conduct of elections. And we have been quick to raise the alarm about the impact on specific groups and to share best practice on how to prevent and mitigate this. These groups range from national minorities and minority language speakers who have lacked access to healthcare and COVID-related information in their mother tongue, to women and children trapped at home under lockdown with domestic abusers, to the danger of disadvantaged school pupils falling further behind their peers because they lack the support, equipment, and internet coverage that have been crucial during periods of online teaching. But we have not only generated advice and guidance, we have provided practical support too. For example, we have offered temporary free access to guidance and standards from our pharmacopoeia, the official reference for the quality control of medicines for developers working on COVID-19 vaccines. We have supplied thousands of items of protective equipment to prison services across Europe. And the Council of Europe Development Bank has invested more than 3 billion euros in over 20 COVID-related emergency projects and issued social inclusion bonds to help fund member countries' mitigation of the pandemic's social and economic effects. Of course, the crisis is far from over. It continues to evolve, and our approach, therefore, does the same. Issues around vaccination are a case in point. Earlier in the crisis, we made clear that everyone should have the opportunity of a safe and effective vaccine. And our bioethics committee confirmed the need to prioritize specific groups at particular risk, while also ensuring that there is no discrimination against others, migrants, asylum seekers, and homeless people, for example. On the issue of compulsory vaccinations, our Oviedo Convention on Human Rights and Biomedicine makes clear that in principle, any medical intervention should be subject to a patient's free and informed consent. Exceptions are possible, but the European Convention on Human Rights itself imposes a strict proportionality test for justifying mandatory measures in sensitive areas like health. Then, of course, we have the matter of vaccine passes, which have been put to extensive use by some European governments in recent weeks. Anticipating this, earlier this year, I sent an information document to all 47 of our member states. This outlines the relevant human rights standards that must be considered when operating such passes. And it was supplemented by guidance issued by our data protection and bioethics committees. Looking forward, there will be other issues to address. Prominent among these will be the long-term consequences of COVID-19 on Europeans' social and economic rights. All too often, the poorest and most vulnerable suffer most from economic downturns. The risk of increased social divisions is that a health crisis feed into a crisis of democracy too. We must ensure that the social rights of every individual are respected. Abiding by the European Social Charter is key to achieving this. And with that in mind, I have made specific proposals for reinforcing the Charter system. This involves member states' renewed political commitment and better and more effective monitoring at the European level. So the pandemic poses specific challenges for matters of European law, and our multilateral response has been important. But while this challenge was sudden and unexpected, other challenges have continued to evolve and emerge. These too require action. Let me give you some important and diverse examples. Take the application of human rights in the digital age. This rise of new, smart technology is opening up seemingly boundless possibilities for how we live and work. But this also requires new measures to ensure that changes in our societies maintain human rights rather than undermining them. Artificial intelligence is a case in point. It causes unease among many people for many reasons. Biometric identification creating an avenue for mass surveillance. Technology, often patented abroad, replacing human input and creating gray areas about who is responsible for its conduct. Algorithms profiling internet users and determining what news we read and what information we see. So the Council of Europe is at work on a legal framework for the development, design, and application of artificial intelligence based on our standards of human rights, democracy, and the rule of law. At our May ministerial session in Hamburg, ministers endorsed this approach, asking for a focus on two elements. First, a cross-cutting binding legal instrument based on general principles and on which negotiations should start by May of next year. And second, the potential for additional binding or non-binding instruments to address the artificial challenges facing specific sectors. For example, we are considering a binding legal instrument on autonomous vehicles and an instrument on artificial intelligence and education. Of course, artificial intelligence is not the only digital issue to address. Our Budapest Convention on cybercrime remains the gold standard for international justice in its field. But technology has opened new routes for crime, often spread across multiple jurisdictions. So we aim to have a second additional protocol to that convention ready for adoption later this year. The text is ready as the result of an intense intergovernmental process involving the EU and non-European countries, such as the US and Japan, that are also parties to the Budapest Convention. And our Committee of Ministers is expected to agree on it in the coming weeks before opening it for signatures and ratifications. Its impact will be to reinforce cooperation, facilitate more effective investigations, and make the online environment safer for citizens. Similarly, we have upgraded our Data Protection Convention, Convention 108. More than 40 years after it was opened for signature, this convention remains the only legally binding multilateral instrument on the protection of privacy and personal data, open to all countries around the world. The amending protocol, commonly called Convention 108+, further enhances the capacity to protect information in light of today's digital risks. Countries that sign up to it are seen as safe players in the digital market, receiving data from other countries more easily and being better able to work with one another to ensure compliance, cooperation, and mutual assistance. 55 states parties have ratified the original Convention 108, and many more countries and organizations have observer status. And it is in all our interests that just as many ratify the protocol and secure its rapid entry into force. I hope that in due course, we will also have a recommendation on a comprehensive approach to addressing hate speech, including online. A draft is out for consultation and will soon be submitted to our Committee of Ministers. Its text will clarify the definition of hate speech, make clear who is responsible for identifying and monitoring it, and outline the necessary legal framework covering criminal, civil, and administrative law, including the regulation of internet intermediaries, with due respect to the standards set by the European Convention on Human Rights. At its core, this is about establishing layers of liability and the measures that governments, internet intermediaries, and others should follow. In truth, governments and international organizations have been slow to take firm action against hate speech at a time where it has been rife on the web. This problem is not going away. In fact, it's getting worse. It ruins lives, and we are determined to address it. We are equally determined to address the threat posed to human rights by environmental harm and climate change. The European Convention on Human Rights already plays a role in achieving this, in interpreting the rights to life and respect for private and family life. For example, the European Court of Human Rights has generated case law with environmental implications, and some national courts have cited the convention in domestic cases too. Similarly, rights contained within the European Social Charter, including the right to protection of health, are relevant here. And in fact, the Council of Europe has a long-standing range of conventions related to the environment. But we recognize the need to consolidate and to progress. In order to do this, we are undertaking a range of initiatives across the organization. Key among them is our work on a new recommendation on human rights and the protection of the environment. This will list principles on which all 47 member states can agree and work to implement. And I hope that this work can be finalized in some time for our ministerial session next May. Importantly, we are also examining the feasibility and appropriateness of modernizing our Convention on the Protection of Environment through Criminal Law, or of preparing a new instrument. Lastly, I want to mention our work on an issue of ongoing importance to every country in Europe and around the world. The Council of Europe's Istanbul Convention on Preventing and Combating Violence Against Women and Domestic Violence is now 10 years old. Its aims are simple and clear: to prevent violence against women, to protect those who become victims, and to ensure the prosecution of perpetrators. Where it is in force, it works. Our monitoring body, Grevio, has so far issued evaluation reports on 17 countries that are treaty members. And they show that every one of them has moved to amend its domestic laws so that these align with the treaty. For example, by adopting a consent-based definition of rape, classifying stalking as a criminal offense, and introducing sexual harassment offenses, such as the non-consensual sharing of sexual images, which has brought so much pain to so many women and girls over recent years. Grevio has also found improvements to the way that such offenses are handled by law enforcement, prosecution services, and the judiciary. The expansion of police units specializing in sexual and domestic violence is a case in point. All of this is good, but there are problems. Violence persists, and the spike that we saw in abuse levels during COVID-19 lockdowns is testament to the fragility of the progress that we have made. More than this, there are political issues too. In parts of Europe, preconceived notions and misconceptions about the purpose of the Istanbul Convention have become established and deterred some countries from joining. On this basis, one of our member states have even withdrawn from it. Our best response to this is to expand the circle of states parties. This means taking every opportunity to promote an open, honest, and positive conversation about the Convention's impact. We need to be clear that this multilateral treaty provides important benefits that no single government can recreate. This is about raising national standards, certainly, but it is also about having a unique, independent, international monitoring mechanism that helps bring about difficult but vital change, and about ensuring cooperation between countries so that their authorities work together and hold to account those who choose to commit crimes against women. 34 of our member states have ratified the Istanbul Convention. Most recently, I received the instrument of ratification from Liechtenstein, and other member states, including Ukraine and the United Kingdom, are also making progress towards joining. So this is a battle that we can and must win on the basis of facts and in the interests of all women. We are certainly determined to do so. Taken together, these topics, COVID-19, digital technology, the environment, violence against women, these constitute some of the most pressing and high-profile challenges of our age. None, not a single one, can be resolved on the basis of any individual country's actions. They are cross-border issues that require a multilateral approach. For this, trust, cooperation, and rules are essential. And a common legal framework is invaluable for ensuring accountability and looking down progress. Many of you listening today play your own role in the success of that system. And I look forward to hearing your questions. Thank you.
Thank you so much, Madam Secretary General, for those wonderful and important words and for the impressive overview of the work of the Council of Europe. When I heard your speech and I thought about the portfolio of Eli projects we're currently conducting, I think there is not a single Eli project for which the work of the Council of Europe would not be of utmost importance. And I read this report on a democratic renewal of Europe. I found it extremely impressive. And I have to say that we need to forward this report. I'm sure all our project teams already know it, but we will definitely forward it to all our project teams, because I think there is such a panoply of extremely important ideas in there, and certainly a vision which the Eli shares. And thank you so much also for stressing that the European Convention of Human Rights is non-negotiable, and for stressing the importance of common legal frameworks. Now, I take it, Madam Secretary General, that you have agreed to reply to a couple of questions our members have asked. A lot of questions came in. I think we need to make a selection. And the first question that came in from an Eli member is the following, and I quote now, "The findings of your report on social rights confirm that the COVID-19 pandemic and related measures imposed by governments have shaken the entire economic sector, leading to higher unemployment figures, and have exacerbated the rise in human trafficking for the purposes of labor exploitation. What are the most important measures recommended by the Council of Europe to combat such trafficking?" End of quote. Madam Secretary General, would you be prepared to answer this question?
Of course, you are right that the COVID-19 aggravated the root causes of trafficking in human beings. Unemployment, poverty, and gender inequality have all increased. COVID-19 related lockdown measures and movements restrictions have also contributed to a surge in some forms of exploitation, and they have diverted law enforcement resources and led to a decrease in identification of human trafficking cases. We are resolute to counter that, first of all, by supporting the implementation of the Council of Europe Convention on Action Against Trafficking in Human Beings, which fully applies even during the emergency measures. Our competent monitoring body, a group of experts on action against trafficking in human beings called GRETA, has been very clear on that point. Prior to the pandemic, I had already identified trafficking in human beings for the purpose of labor exploitation as one of the major challenges facing Europe. In November 2019, I had presented a roadmap on strengthening action against this crime. Among the outcomes of this roadmap was the publication of a compendium of good practices and a guidance note from GRETA, recommending that states take a number of priority actions. I will give you just 3 examples: the adoption of comprehensive national strategies for combating trafficking, including specific measures to address labor exploitation, especially in high-risk sectors such as agriculture, food processing industries, or domestic workers. The adoption of measures protecting victims, for example, by establishing a simple but safe mechanism to report abuses, or facilitating easy access to unpaid wages and compensation, and increasing the costs for traffickers, if one may say so, for example, by including labor exploitation within the definition of criminalization of trafficking in human beings, expanding the mandate and resources of labor inspectorates, and strengthening the criminal law response tools available. We will continue to work with our member states and other states parties to the convention, such as Tunisia, to put such measures in place. The work carried out in the framework of our roadmap also made clear that a new recommendation from our Committee of Ministers to Member States would have a strong added value to complete the international legal framework in this area. In April, the Committee of Ministers set up a new intergovernmental body to that effect, and the preparation of such a draft recommendation will now start.
Thank you so much, Madam Secretary General. And if you permit, I would pick another COVID-related question. And I quote, we know that the Council of Europe emphasized in its resolution 2361 from 2021 that vaccinations are non-mandatory and that no one shall be under political, social, or other pressure to be vaccinated if they do not wish to do so, and that no one should be discriminated against for not having been vaccinated due to possible health risks or not wanting to be vaccinated. Now comes the question, what would be your or the Council of Europe's position on recent policy measures and legislative acts in some European states that aim at incentivizing vaccination and providing more liberties for vaccinated people? End of quote.
This is indeed a very topical question. The text you are referring to is a resolution from our Parliamentary Assembly of the Council of Europe that is, I quote, an expression of view for which the Assembly alone is responsible, end of quote, according to its rules of procedure. On the substance, we certainly all agree that we need to overcome the COVID-19 crisis and get back to normal life as soon as possible. States have a duty to act and a positive obligation to protect life and health, and vaccines are an essential part of the strategy to combat the pandemic. According to the commitments they freely undertook by joining our organization, the policies and laws adopted by our member states must, of course, be compatible with Council of Europe human rights standards. Take compulsory vaccinations, for example. In principle, any medical intervention is subject to the patient's free and informed consent, according to our Oviedo Convention on Human Rights and Biomedicine. This does not mean that mandatory measures are not allowed, but they are subject to a strict legality and proportionality test with reference to the protection of health as required by the European Convention on Human Rights. Also, a good number of European states have developed passes or certificates to prove that the holder is vaccinated, negative, or immune to COVID, enabling them to enter cinemas, gyms, restaurants, etc. Systems differ from one another, but it is essential that they are designed in such a way as to respect fundamental rights and freedoms, such as data protection, the prohibition of discrimination, freedom of movement, and so on. I would like to underline that under the principle of subsidiarity, it is for national authorities and courts to develop their own solutions compatible with our international standards. We are here to support them in doing this, and since last spring, we have provided advice to our member states in this respect. Lastly, and importantly, the implementation of the European Convention on Human Rights is upheld by the European Court of Human Rights. Hundreds of applications concerning COVID-related laws and rules are already pending before the court, including on passes and compulsory vaccinations. According to the court's case processing strategy, by which cases raising the most important issues, so-called impact cases, are processed expeditiously. First judgments and decisions concerning COVID-related measures, such as lockdowns, have already been delivered, and I have no doubt that this will continue in the times to come.
Thank you so much, Madam Secretary General. And if you permit, I would now pick a non-COVID related question, which I think fits very well, bearing in mind the words you just spoke. And I quote again, 8 years after it was adopted, Protocol 15 to the European Convention on Human Rights entered into force, following the final state ratification by Italy in April this year. To what extent do you, Madam Secretary General, feel that the amendments, which will begin to apply after the transition period ends on 1st February 2022, as well as other recent reform measures by the Strasbourg Court, such as the prioritization of so-called impact cases, will quieten debates about reforming the convention system, debates which the ELI was part of in 2012, insofar as the caseload of the court is concerned? I think you partly touched already upon it, but please, Madam Secretary General, if you were so kind to reply to this question.
The effectiveness of the convention system is of great relevance for the Council of Europe as a whole, because the convention is the cornerstone upon which it is founded. It is one of its distinguished core features that each of the 840 million Europeans can apply to the Strasbourg Court. The convention system must function well, and this inspired a whole decade of reforms, so-called the Interlaken process, which started in 2010. 3 protocols to the convention have been adopted or entered into force. Court procedures were amended, innovative IT tools put in place, and so on. But there are limits to what streamlining and optimizing procedures can bring. So in November last year, for the convention's 70th anniversary, our foreign ministers marked the end of this Interlaken process by agreeing that for now, no more comprehensive reform of the convention machinery is needed. But they were clear that further efforts should be made by the Council of Europe as a whole to ensure that the convention system can continue to respond to the numerous challenges Europe faces. This means better implementation of the convention at national level and ensuring the full and speedy execution of judgments from the European Court. This is all the more important now that the court prioritizes the cases that have the biggest impact. And it is also a big challenge at a time where the court is regularly attacked and where there is sometimes a lack of political will to promote and uphold its work. This is why supporting the convention's implementation is the first of our strategic priorities, as agreed by our Committee of Ministers in May. Much more will be done, for example, to support national judges, to expand knowledge sharing on the convention, to reinforce the supervision of the execution of the Strasbourg Court's judgments, and so on. The convention system is unique. 47 member states having freely decided to abide by the same fundamental rules and to submit to the final decisions of an international court. But with the size reached by the system and the complexity of issues handled by the court, including a strong increase of cases with an interstate component, I have no doubt that debates about how best to keep the machinery running will continue. That's a good thing. It is right to ask the difficult questions and to find the necessary solutions. European lawyers like you will have a lot of work ahead of them.
Well, thank you so much. And if you permit, I realize the time is already far advanced, but there are so many questions posed by our members. So if you permit, I would dare to still ask 1 or 2 further questions. Let me pick a short one. Quote, "We can observe first attempts in Europe to regulate new technologies such as AI, which present both great opportunities and risks for human rights. What would, in your view, be the most important safeguards to consider when adopting these new technologies?" End of quote.
The Council of Europe has been working for many years on how to ensure that technological developments are compatible not only with human rights, but also democracy and the rule of law. Our data protection and cybercrime conventions, our Committee of Ministers' recommendation on the human rights impacts of algorithmic systems, and the guidance on facial recognition published by our Data Protection Committee are all pertinent examples. Concerning specifically artificial intelligence, we set up an ad hoc intergovernmental committee on artificial intelligence, the CAHAI, 2 years ago. As I indicated in my speech, last May, our foreign ministers gave a strong push to this work, which they want us to take further, notably on starting negotiations on a cross-cutting binding legal instrument on artificial intelligence based on general principles. Now, to reply to your question on safeguards, I would say that first of all, it is important to bear in mind that artificial intelligence is a tool. It should never be the master. Also, the usefulness and adequacy of artificial intelligence depend almost entirely on the quality of the data with which the decision-making algorithm is trained. I would cite only a couple of human rights and rule of law safeguards to be applied in relation to artificial intelligence. IA should never entirely replace human decision-making. There must at least be human oversight with the processes and results of IA. The quality and representativeness of data sets used for training artificial intelligence should always be ensured. It must be possible to hold designers, developers, and users of artificial intelligence legally accountable for artificial intelligence decision-making, which results in breaches of human rights. And there must be an effective remedy against decisions taken by or with the assistance of artificial intelligence. Again, this is not exhaustive, and I can only invite you to consult and follow the evolution of the CAHAI's work for more detail.
Thank you so much, Madam Secretary General. We will certainly do so. And if you permit, if you can still stay a couple of minutes with us, I would like to ask one last question because it directly relates to one of our projects which we are planning to take on board. And I quote that Eli member who's involved in the preparation asks, in your report, it is mentioned that COVID-19 has resulted in new court procedures and anticipated backing in cases and delays to important judicial appointments. As Eli is planning on embarking on a new project on the digitization of justice systems, what role do you think technology could play in future court proceedings? End of quote. And I promise this is the last I will read out to you.
The Council of Europe has been supporting its member states since the early 2000s in their efforts to introduce more efficient IT tools in the courts. The development of technology is already making justice easier to access and making the judicial machinery faster, more efficient, and more transparent. The Council of Europe developed strong standards and tools in this field and can only invite the European Law Institute to take them into account and promote them in the project you are referring to. For example, the recent guidelines of the Committee of Ministers on Electronic Evidence in Civil and Administrative Proceedings, the European Commission on the Efficiency of Justice, CEPEJ, guidelines on how to drive change towards cyber justice, and the European Ethical Charter for the use of artificial intelligence in judicial systems and their environment. I would also invite you to stay alert for developments resulting from new standards recently adopted or currently being prepared, such as in the area of data protection, artificial intelligence, and cybercrime. Expanding the installation of new technologies in courts, increasing the use of open data and predictive strategies will be the challenges of the digital revolution in justice. It is fundamental that rule of law principles be upheld in this context. The protection of fundamental rights must be ensured. respect for privacy, freedom of expression, the right to be forgotten, and the rights of defense and the adversarial principle. The digitalization of justice must be the subject of unified national strategies to avoid courts taking isolated initiatives, which could lead to inequalities among litigants and threaten the independence of justice. Also, legal certainty is key, including how to verify and ascertain the identity of participants in remote proceedings. So rules governing how this should be done must be clear, robust, and fair. This is fundamental so that digitalization can fulfill its first aim to make justice more efficient in conformity with Article 6 of the European Convention on Human Rights, the right to a fair trial in a safe legal framework where justice remains human. The Council of Europe will remain fully committed to that aim.
Thank you so much for that important guidance for our upcoming Eli project. And I would have many more questions submitted by our Eli members, but I do not dare take more of your time. So I think I would like to thank you wholeheartedly for your wonderful keynote and for staying with us so long and for all the inspiration and support which the Eli and its project work receives from the Council of Europe.
Thank you. Thank you very much for the invitation. It was a pleasure sharing what we do and what we plan to do in the area we share, I think, common interest in. So all the best for the work of your conference, and to all the members of Eli, all the best for your work and our common work for better Europe in the future regarding human rights, democracy, and the rule of law.
Thank you so much, and I'm sure that our organizations will stay in close contact and exchange views on these important topics, which are so important for Europe nowadays.
Thank you.
Thank you so much again.
Bye-bye.
And now I will turn to not saying goodbye, no, by no means. This is the opening ceremony, so we will have our first panel at 5:15. Make sure you join us for that panel, but before you switch off your cameras and log on to the next Zoom webinar, we would all like to invite you to listen to the European Anthem, the Ode to Joy, played out by the European Union Youth Orchestra. So this recording has been made available to us with kind permission from the Karajan Institute and SCHOTT. And we have accompanied it with some slides, which those of you who were already present at the decennial celebration may recognize. So let us listen together to the European Anthem and see you soon again at 5:15 for the first panel of our annual conference.